afternoon, Professor Smart.
Good afternoon.
I'd like you to turn to tab 19 of the compendium exhibit B.2, and there you will find the Hutchins trial demonstrative 145, and I wanted to ask you a couple of questions about hydroelectricity, and I thought this might refresh your memory.
Okay.
So the first question is that involves the statement in the second bullet point where Mr. Hutchins was of the opinion that there must have been some relevant expense associated with collecting the water rental fees by the Crown. You understand that to be his opinion?
I didn't, but
Oh.
I'm reading the slide and I see that opinion offered.
He identifies in the first bullet that there were no expenses in the Ontario public accounts that were specifically attributable to water rental fees, but he assumes there must have been some expense. You see that?
Yes, I agree. That's exactly what he did.
And do you think he's wrong in doing that?
Well, I think there's no basis in the PAO as he stated on this slide, and that because the PAO is our starting point, that it's not appropriate to do so.
So, would you at least agree with me that whether or not something's recorded in the Ontario public accounts in relation to water rental fees collected, that in reality, in the real world, there probably was at least some expense of collecting the water rental fees?
If there was, it would be in the PAO somewhere.
Well, I mean, certainly there must have been someone who was sitting in an office, either collecting rental checks or sending out rental invoices. There must have been somebody somewhere. You would agree with
I
that?
agree. I agree.
But we don't find it in the public accounts.
It is there, but not specifically identified. All the expenses of the province of Ontario are recorded in the PAO.
And so you had used the expression during your direct testimony that the public accounts are sacrosanct. I believe that's your words.
Yes.
So in your opinion, was it wrong for him to include in 2% of revenues as a proxy for expenses for hydro?
We didn't do so. We assumed 0% specifically attributable to that because we found no such entry in the PAO. Mr. Hutchins took a different approach. I agree.
You agree that he took a different approach. I understand that. But do you think the judge should prefer your approach on this issue?
Yes, the general principle for me is that we should only include things that are in the PAO. And I could briefly expand. Certainly, you're right. At least one official did that. He either worked for the Treasury, the Ontario Treasury Department, or he worked for the Ministry of Natural Resources. It would depend on the year, he or she. And so it might or might not be included in the administrative expenses of the ministry for that year. We have, both of us, Mr. Hutchins and myself, had a standard approach to dealing with administrative overhead. I think it deals with the issue of collecting this one charge just fine, and there was no need to add an extra 2%. And so I mentioned that in, I think, the reply report I co-authored with Professor Bodway. I didn't mention in my direct testimony, and that should indicate to you how important I think that particular choice is here. Not very important.
Can we turn to your slide deck 38 of 161, please? Now, slide deck, I see you're just turning to it now, and I'll begin in a moment.
I'm there.
So slide deck 38 of 161 of your demonstrative deals with MPT or mining profits tax for the year 1935.
Yes,
And this is one of those things, oh, there's the word sacrosanct right at the bottom, where you say the public accounts are sacrosanct. The second last bullet is what's troubling me. I'm gonna read what it says. Result is to double count MPT revenue by 60 million. I'm gonna pause there. That's 60 million at bond rates, correct?
yes,
And then in brackets, 526 million at Hutchings interest rates. That's over $500 million.
yes.
Are you alleging that he made a $500 million error at 60/40 rates on the bottom line because of what happened in 1930, his treatment of MPT in 1935?
These are province-wide values. All of the comparators that I created were from my province-wide accounts. So specific answer, no. When you say bottom line, you mean the RST share. This is the province-wide amount.
But I mean, if we're trying to give the court some sense of the importance of issues, wouldn't it be important to let the judge know how much of that 60 million or 526 million was attributable to the RST in 1935?
In this case, I think the general principle is very important. It's more important than the quantities. And that's what I've emphasized on this slide. I think there's a reason why I kept doing it with the province-wide amounts, which we were pains to observe to the court in my examination in chief, but which I haven't mentioned the reason why we did it that way.
I'm going to suggest to you the reason why in your slide deck, it identifies things that, it identifies consequences of what are alleged errors by Mr. Hutchings at present value reports reported at bond rates and his preferred interest rates, is to show, to demonstrate to the court, or to try and demonstrate to the court that it matters a lot to the bottom line. Would you agree with that?
I agree. Part of the purpose is to show the magnitude. I believe this does show the magnitudes, not for the bottom line. There we have to multiply by the share that Mr. Hutchings assumed should be apportioned to the RST. And I didn't know precisely what that number was. I knew it was close to my own, but I didn't know the exact share that he apportioned to the RST because I could not find that in his work papers. And so this was the most precise point of comparison that I could provide.
Didn't you look to his work papers?
I did, and I could not find those shares.
Well, it just so happens that the compendium actually has that excerpt of the work papers at tab 20. Can you turn over to tab 20? And it's from Mr. Hutchings' work papers, table 1B, Roman numeral 1, cell C49. And I've had it yellow highlighted. And these are in nominal dollars, I'll grant you that. It's not in bring forward dollars, but in 1935, Mr. Hutchings said the share of mining profits tax, which he a revenue that he takes, is $258. You see that?
Well, so that is not a share. So I'm afraid I can't agree with you. That's a dollar amount. I said I don't have his shares and I don't see shares on 49. My own accounts, which I used, are in province-wide aggregate dollars. As I said, I would then need to multiply by Mr. Hutchings' percentage share of that amount that he attributed to RST. I didn't know what it was. It was close to my own, but not the same. That extra level of complication prevented me from doing what you're suggesting. Mr. Hutchings can do it because he knows more about his work papers than I do. And I think that's what we're looking at now.
Well, I don't want to quibble about a share or a dollar amount. The reality of it is that, and I'm going to use from Mr. Hutchings' analysis, there was $258 in 1935, and no matter what interest rate you take, whether it's your bond rate or his 60/40 rate, you do not come anywhere near 60 million or 526 million in present day values. Would you agree with that?
I have not reviewed this part of the work papers, but I am very surprised by that amount. We start with $526 million present value. These are nominal. Am I right? These are nominal.
When you say these are nominal, you mean the nominal at page 49?
The numbers that you directed me to on page 49 of your compendium.
Yes, they're nominal dollars. That's correct.
I'm not sure how to convert then.
So you need to know the percentage.
Well, now I need to know you asked me to comment on the number. The number would need to be a present value 2020 dollar before it would be economically meaningful and in a way that would afford me the opportunity to opine on whether it was reasonable or not. I was thinking through my $526 million province-wide, and I'm guessing that our share of mining revenue for RST in that year was about 1%. And so when I multiply 1% by 526 million, I get about 5 million as the present value amount. And it is possible that at Mr. Hutchings' present value conversion factors, that 5 million that I'm estimating would be equivalent to 258 nominal dollars, but I do not know. I do not know because
Well, I'm sorry. I'm sorry. Am I interrupting you? Do you need to say anything more?
I don't know how to work with nominal dollars and they're not relevant.
Can you please take a look at your slide 2816 of 161? Because the information is right in your slide deck. You have a table in your nominal values report that identifies MPT apportionment and can you read for me, or let's read it together. During the period 1930 to 1939, of which 1935 is 1, your data ascribes 0% to MPT. You say the plaintiff's data ascribes 0% to MPT, and the difference, of course, is 0%, all things being equal. Now, I appreciate that the number is so small that it's less than 1, and it doesn't even show up on your chart here on page 28 of 161. So my question, sir, is I put it to you that before you let the court know in direct that there was a close to more than $500 million issue, you knew it was close to 0% of the $500 million at 60/40 rates. Is that true?
I didn't know it was 0, sir. I disagree. I know
I
what
said close to 0. I'm not suggesting it's 0 because I am suggesting it's under 1% and it's close to 0, and you had the data before you made up these slides.
Would you wish me to finish my response?
Sorry, I cut you off if I did. Go ahead.
I was about to say, I told you a minute ago that I believed it to be about 1% in 1935. This table shows us that the average over the period from 1930 to 1939 was, as you said, less than 1%. So it's in the ballpark. I guessed 1% based on what I know of my work papers. You pointed me to something that is entirely consistent with that. A minute ago, I said 1% of 526 million would be 5 million. It may be slightly less than that. Based on this, I would probably revise my belief downwards from 1% to something a little bit less than 1%. But it's possible that it's 1% in 1935 and it averages to a little less over the full decade.
Can I suggest to you that if you look at your work papers, you'll see that it's 0.2% of 1% for 1935? Does that maybe ring a bell?
It doesn't, but we can work with that. And again, I rely on your goodwill. So I said 1% would be 5 million. 0.2% of 1% would be $1 million. That would be the implication for the present value.
0.2% of 1% of $500 million is $1 million? Is that what you're saying?
I think so.
I do not believe that you can just divide it up like that because it's spread over time and I don't think it amounts, well, I'm not going to debate mathematics with you. I'm not good enough at it to actually have a proper statement question for you.
I think was the question 0.2 of $500 million is $1 million?
0.2% of 1% of $500 million at 60/40 is what the witness is saying. The 60/40 bring forward would result in.
Thank you.
Is that a fair summary?
I think so.
Now, let's return to the slide deck for a moment and go to tab 19. Of the compendium, excuse me, I apologize. Tab 19 of the compendium, volume 2. And here we have Mr. Hutchings' interpolation of the data on MPT.
Excuse me, which tab?
Tab 19. Page 48. Just happens to be 48 at the top right-hand side because of the way the document printed out. And this is from Mr. Hutchings' trial demonstratives, page 219. And as I understand it, just to be clear about where you and Mr. Hutchings differ, Mr. Hutchings said or felt was of the opinion that it didn't make sense that there would be a dip in monthly receipts and then reported in a 17-month period. And you explained that there was in your report, and I think on the stand as well, you explained there was a change in the fiscal year end.
Yes.
Now, Mr. Hutchings looked at the data, and you've heard of something called forensic accounting.
Yes.
So when the data set has an unexplained result, you question it. That's what reasonable economists do. Would you agree?
No, I don't agree.
Okay. So if an economist sees results that don't seem to make sense, they don't question it?
Yes,
Okay.
that we do.
All right. So in this particular instance, Mr. Hutchings in column number 7 looked at the monthly amounts, the monthly mining profits tax per month, and observed that in the years 1930 to 1934, they were trending steadily upward by an amount, and that by 1934, the monthly average was $89,485. And according to your monthly results, Mr. Hutchings was trying to demonstrate by this slide that you agree, that the two of you both agreed that in 1934 it had gone up. I don't believe it's quite exponential, but revenues had been going up, reached $89,485 per month. And then in 1935, in your understanding, and I guess that's because public accounts are sacrosanct, dropped to zero in 1935. Is that fair?
I gave my reason in my examination in chief. It's different than what you said.
Okay. In 1936, you had, Mr. Hutchings has your averages being $82,392 per month. And then in the next year, in 1937, it jumps up to $130,307 per month. You see how he's assessed or taken a look at the monthly figures. I'm not asking you to agree that he's right, that this is how he has assessed the monthly figures, and those monthly figures mathematically are correct. That's what I'm trying to establish here.
I'm not sure what he's doing. It's not apparent from this slide. It says per month, but I don't know what that means.
All right. Let's use a hypothetical. Maybe that can get us where we need to go. Okay?
Yes?
Yes, thank you, sir. The hypothetical we're going to use is that the data set demonstrates that in 1934, the monthly average mining profits tax was $89,485. And then the data showed that for 5 months in 1935, it dropped down to zero. And then for the next 17 months, it jumped to $82,392 per month. And then on the 18th month, starting the 12 months starting in 1937, it jumped up to $130,307. Would you agree with me that if that's the data that Mr. Hutchings saw, it was reasonable for him to ask the question, why is this happening?
No, I don't agree it's reasonable because this was not a monthly tax. And so making monthly calculations of it makes no sense. As I explained in my examination in chief, it was a tax paid annually. The 1934 data show you the taxes paid in the fall of 1934, and the 1936 data show you the taxes paid in the fall of 1935. The 1937 data show you the taxes paid in the fall of 1936, and so on. There is no anomaly, and there is no reason to divide by the number of months in the fiscal year, because that's not the way the tax was levied or collected.
So you don't see any discrepancy to be worried about from the fact that the average between 1934 and 1937 went from $89,485 per month down to 82 and then shot back up to $130,307 per month. You don't see any discrepancy there or any problem there?
I don't see any problem because it was not a monthly tax. And as we are all aware, the 1930s was a tough time economically. It was a tough time for prices themselves. They were whipsawing, as economists would say, over that period. Whipsawing, meaning sharp changes very suddenly.
Well, would you agree that this is one of those things where economists can have differences of opinion?
No.
Okay. Would you agree with me, sir, that the logging tax should have been included as a revenue source?
No,
You take the view that the public accounts are sacrosanct. Do the public accounts say anything about logging tax?
yes, they do.
Are the logging tax revenues recorded in the public accounts of Ontario?
Yes,
Are they recorded under the forestry department, or where are they recorded?
I don't recall.
Perhaps we can take a look at compendium tab 21 and see what, if we can get some assistance from the Ontario Committee on Taxation. I'd like to, this is tab 21 of the compendium. Part of trial exhibit 1-5293. It's excerpt of the Ontario Committee on Taxation, the Provincial Revenue System, 1967, Volume 3, electronic pages 383 to 385. And I wonder, sir, if you could turn to page 367 of the document, which is at page 53. Of the compendium. Actually, maybe we should go back first to page 51. It's under chapter 33. And there's the heading, the Logging Tax Act at page 51. I apologize, page 51. Now, have you seen this document before today?
Yes, it's cited in my report, and I mentioned it in answer to a question in my examination in chief.
Now, at paragraph 46, the authors of this report say, in principle, or write, excuse me, in principle, additional provincial revenue from logging through such devices as the logging tax.
Excuse me, may I interrupt for a second? I don't see that on page 365 you just referred me to. Can you get me
I'm
back to
sorry,
where I need to
I
be?
thought yes. Let's go back to page 367 on page 53.
Okay, sorry, and which paragraph, please?
Paragraph number 46.
Okay, go ahead.
In principle, additional provincial revenue from logging through such devices as the logging tax and its accompanying credit arrangement is justified only if the province is in fact deriving less than fair economic rent from its system of crown charges. This system may obtain in that the existence of federal taxes will reduce the amount which the timber operator retains to cover his return on capital and rental payment to the province. The present credit system, which absorbs the entire burden of the logging tax on the operator while producing a transfer of funds from the federal to the provincial government, is evidently based on this premise. And the premise is that the province is in fact not receiving its fair economic rent from the system of crown charges, right?
I'm going to need a minute to read. Okay, I think I disagree, Mr. Schechter. It's hard to parse. First time I recall reading this paragraph, but I think I disagree with what you said the premise means.
So you're suggesting to me, sir, that these authors are suggesting that the province is not in fact deriving less than its fair economic rent from the system of crown charges?
I do not believe this premise refers to that proposition that you just made with regard to less than, did you say fair economic share? In any
A
case,
fair economic rent from its system of crown charges.
yes, I don't think this premise refers to that proposition.
Do you know what proposition do you think it refers to then?
I think we should refer back to the immediately prior sentence and the This is tough. No, the first sentence and the phrase of that sentence, it begins with the word if, because I think that identifies a premise. If something is true, then something is true. So in the very first sentence of 46, the phrase, if the province is in fact, oh, but that's your phrase. I'm sorry. I'm going to have to ask for another couple of minutes.
While you're reading it, and I'm not gonna ask you to comment, you can wait, but you might want to read the balance of this page, because it might help you come to a conclusion and have you agree with me. At least I'm hoping that you'll read it and agree with me.
I think I've got it now. The premise referred to that you asked about refers to the statement, this situation may obtain in that the existence of federal taxes will reduce the amount which the operator retains to cover his return on capital and rental payment to the province. So the premise is federal taxes reduce the amount the timber operator retains to cover his return on capital. And I can offer an economic interpretation of that phrase and explain why that's the premise that's relevant here, if you wish.
Did you read the bottom part as well?
Didn't yet, I'm sorry.
Yeah, why don't you read the bottom part?
That is the rest of this paragraph
Yes,
46?
Yeah, read the
Will do.
rest. And when you're finished reading, I'll ask you a question.
I'd ask you just to let me read it. It
Yeah.
is a complex text. Excellent. I've read up to the word levied, and I have not read the following recommendation. Please go ahead.
No, please read the recommendation as well.
Okay. Thank you, that's up. I've read it all to the end of the page.
All right. I'm going to suggest to you that what the authors are trying to communicate is that there's a more efficient way of Ontario collecting a fairer, a more appropriate share of the fair economic rent from its system of crown charges by eliminating the tax and just getting more and preferential, an additional share of income taxes. Would you agree with that?
Yes, I do. An additional share of federal income taxes. Yes, I do.
Okay. And with that, then, would you agree that the logging tax is in fact a tax that helps the province recover more of the economic rent from its system of crown charges?
I do not agree with that, and I believe paragraph 46 supports my view that it was viewed as a way of transferring funds from the federal treasury to Ontario that created no extra burden on the logging companies.
Well, isn't it a little bit of a sleight of hand? I mean, you have a logging tax that's a revenue, and then it becomes a tax by agreement with the federal government. that somehow the Anishinaabe don't get to share, and that almost seems like a sleight of hand. I mean, I don't know where the rabbit goes into the hat, but it doesn't seem like you would change the definition of logging tax because of that. Are you suggesting, sir, that the logging tax would have been a revenue source if there wasn't federal income taxes, credits and provincial credits? Is that what I'm to take? I'm not sure I understand your position.
You asking me to restate my position?
No, 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 no. If there were no federal federal exchange or paying of income taxes or tax credits by the governments to the industry, would this be a logging tax if there was no taxes? That's a bad question. It's not even a fair question.
Thank you.
Yeah, and I apologize for that. Would you agree that the logging tax would be a shareable revenue source in your calculations if there was no tax credits given to the loggers?
If it had not replaced a corporate income tax, therefore being a relabeling of the corporate income tax, and if they had not guaranteed, it had not been the case that those taxes were creditable against federal taxes, so that the impact was simply to transfer funds from Canada to Ontario. If in the alternative, hypothetically, this tax were introduced de novo in the absence of any such corporate tax offsets, then I would look at it with an open mind about whether it was tax on resource rents.
So you and Mr. Hutchings disagree on what, on the characterization of the logging tax?
You do, yes.
It's 3:30. I think now would be a good time for a break because the next section will probably take up the balance of the day.
Thank you. 15 minutes.
Professor Smart, we're going to go into an area which I'm going to paraphrase as being double counting. And you might recall from the back and forth between you and Mr. Hutchings that he had identified at paragraph 70 of his reply report that he was of the opinion that you had double counted a number of expenses. Do you recall that?
Yes.
And perhaps if we just take a look at compendium tab 22, page 54, you'll see his paragraph 70 where he identifies how he understands the error. He gives a brief explanation and then has a full appendix A attached to his reply report. Do you recall that dispute between him?
I do recall it, and I reviewed the documents in the issue during the lunch break for your information.
And do you agree that you still do double count?
I do not agree that the issues raised by Mr. Hutchings in Appendix A constituted double counting, and we have changed those numbers that he was referring to for the years up to 1994. So I'm certain that I do not agree with the statements in paragraph 70, but I limit my disagreement for the moment to the years up to 1994.
All right, so up to after 1994. Would you agree with me that you still double count from 1994 to 2019?
Having read through your compendium, the new issues that you are raising, I'm now not sure about the period 2000 to 2019 that your compendium highlights.
Well, I'm going to suggest to you that the problem persisted from 1991 to 2019. Would you be able to agree with that?
No, as I said, I'm confident there was no double counting up to the year 1994, nor in respect of the points raised in Appendix A.
But you have looked at your own, I mean, let's take a look at what's in tab 22. And when we get to pages 58 of the compendium and following, all we have done is screen captured your May 2023 work papers. And you've reviewed an illustration from the year 2000, and you agree that there is double counting in 2000?
I'm just not sure. Mr. Hutchings' Appendix A highlighted row 54 and said it was a double counting. I read what he wrote and I noticed that row 54 of our file, my file, which is displayed now on the screen on your compendium, page 58. Row 54 is not included. Its exclusion equals 1. That means it's not included. And so reading through what Mr. Hutchings wrote, it was apparent that he was mistaken. There was no double counting for that year where he highlighted row 54. But I see that on page 58, there is nothing in row 54, and you're now highlighting row 52. And I'm uncertain now about whether there is double counting or not for this year 2000, which was not pointed to in the screenshots that Mr. Hutchings included in his report. So this is new to me as of the lunch break, and I'm just not sure right now, but I have estimated the magnitude that is at issue.
You've estimated the magnitude for the year 2000?
For all the years after 1994 where there might be an issue.
And how did you estimate that magnitude?
I looked at the amounts in rows 58 and 52, one of which may be a double counting.
When you say one of which, can you tell us which might be a double counting according to you?
Try to anticipate what I thought you were going to tell me. So
I'm going to wait for you to tell me, and I'll tell you if I think you're wrong.
you wrote on this slide, because row 52 is a total, it should not be included. And that is the issue.
Sorry.
That quote, because row 52 is the total, it should not be included.
Can I be so bold as to suggest to you, looking at page 58, that what you would intend is you would have intended to capture as an included expense 112,637 sorry, 112,637,588 as the expense to be captured. Would you agree with that?
Based on what I'm seeing now, I think it's reasonable to think that I meant to capture the green highlighted box and not the blue highlighted box. And it does seem as though I'm capturing them both here. If I can remember just one more explanation in one sentence. Mr. Hutchings emphasized row 54, and he said that was double counting in the year 1973, because that was the relevant total in that year. And because row 54 is not included, I inferred that he was just wrong, but you're highlighting a different row and a different year, and I cannot at this distance be entirely sure, but I agree with you. It looks like both are included, at least this far in my calculations they are. I haven't been able to verify what happens at the very end of all the calculations. But based on what you're showing me, I tend to agree with you. There may very well be a double counting for these years that you're now highlighting to me for the first time.
Well,
Sorry, in your last sentence, for these years, can you just give me on the record what years you say you tend to agree might be double counting?
For the period, quoting from slide page 58, for
Yes.
the period 2000 to 2019.
Thank you.
And I think you were going to suggest that somehow you managed to figure out we call it the bottom line effect. Or am I misunderstanding what you were going to wanting to tell the court?
Yes, if by bottom line, you mean impact on present value of RST and CRs and annuities, if you wish.
Well, maybe your counsel wants to know about annuities. I'm more interested in NCRRs. How would you calculate that? How did you do that over lunch with reference to the data? What did you do?
I took the amounts in row 52, which you've highlighted in blue, which I believe you're asserting I incorrectly counted, and I'm not sure. So they're in dispute. I added them up for all years
From
1997 to 2019, and I added compound interest to bring them to 2020 present values.
Let me stop you right there. If I can ask a question. Why did you choose 1997?
Because as
I
far,
happen to think that's the correct year, but why did you choose 1997?
because it was the first year for which, I think this is right, there was any entry in row 52.
Okay. And I believe you're correct on that. So we start with the double counting error, or what I think is a double counting error in 1997. It goes through to 2019, and you did some calculation, and I stopped you, and I please continue. How it reverberates through present values.
Then I guess that during this period, the RST share of forestry is 20%. Not exactly sure, but it's on that order. And so I multiplied by 20% and arrived at a total bottom line impact on NCRs of approximately $400 million in present value. If I made a mistake here, I apologize for it. It was not highlighted to me in the report in a way I could understand. It would change, if I made a mistake, it would change our estimated NCRs for RST present value from minus 4.5 billion to minus 4.1 billion.
Or another way to put it is, it would put your calculation of expenses in lockstep with Mr. Hutchings' calculations of expenses in this regard, in terms of identifying what expenses should not be double counted. You understand? Maybe I'm not making myself clear. No?
I think I understand. I don't fully agree with what you
Okay.
just said.
I'll try it again. If you made a mistake and what you're telling the court is it appears that you did make a double counting mistake, from 1997 to 2019, that is in accord with Mr. Hutchings' concern that you had made a mistake.
Mr. Hutchings highlighted row 54, which is excluded.
But otherwise,
He did say there was double counting. He called my attention to row 54, which had positive values in earlier years.
yes.
And because it is not included, I believe that he was in error. Mr.
Schachter,
Schachter is calling my attention to row 52 for a different year. And I'm inclined to change my opinion, or at least go so far as to say he may be right. Mr. Schachter may be right.
Thank you.
um, just before I forget this, I think it's an important point. Would you agree with me that Mr. Hutchings in his NCRR calculations does not seek to include any tax revenues as part of NCRRs?
I think you're asking me, in his $56.9 billion estimate of RST NCRs, are there any income tax revenues? And I believe the answer to that is no.
Thank you. I want to turn to some questions about risk adjustment, if I might. Now, in order to save court time, as we saved court time, substantial court time on the double counting issue, are you prepared to admit that there is no support in this case to risk adjust the NCRRs, whatever numbers the judge decides are the correct NCRR numbers?
I don't agree. Had to try.
Things were going so swimmingly. Can you go to page 19 and paragraph 52 of your present value report for a minute? Now, beginning at paragraph 52 and following, as well as at appendix D at page 73 of your report, and at slides, demonstrative slides 132 to 138, you sought to explain why risk adjusting of the net Crown resource revenues is appropriate. And do we need to take you to those slides and appendices and pages? Or is that a fair summary? I think I've caught all the areas where you presented your position.
I'm fine for now.
Okay. When you proposed the risk adjusting the NCRRs, its effect was to dramatically reduce the present day amounts owing to the Huron plaintiffs, and also had the effect of reducing the negative amount your NCRR calculation would have for the RST. Is that correct?
To break it down, the first half was a question about some data that are redacted. I don't have access to them and I don't recall them, so I can't answer. The second half, I would have to hear again, if you please.
Your risk adjustment of the NCRRs had the effect of reducing the negative amount of your NCRR calculation would have to RST.
Yes, it's just not only a smaller negative as implied by what you said, but it becomes a positive number instead.
Based on your most recent numbers, correct?
Yes,
But not based on your original numbers, which you were prepared to defend in court.
yes,
Is it fair to say that the reason that you decided to use a risk-adjusted NCRR model was to end up with a result that you believed was fair?
I think that, yes, in the sense that the risk adjusted present value captures value, expected value from an 1850 perspective, accounting for the uncertainty in those expectations. So it's a good measure of value, and I believe that fair outcomes in this case depend on economic values, because that's what the augmentation clause says.
At paragraph 53 of your report at page 19, you write that risk-adjusted present value attempts to view the augmentation promise from the perspective of treaty parties. And I take it you mean from the perspective of the Robinson Superior treaty parties. Is that who you mean?
Yes,
Not treaty parties of people in British Columbia or Alberta, but the Robinson Superior treaty parties.
yes,
Recognizing that the NCRRs actually collected over time could not have been perfectly anticipated in 1850. You see that there?
yes,
Now, would you agree with me that the risk-adjusted approach you used seeks to value the treaty territory in 1850 as though the Crown was trying to figure out what to pay on a one-time payment basis?
it's an upfront measure of value of expected future NCRs. So therefore, it's a lump sum measure of how expected future NCRs would be, what they would be, what their value would be. Could you repeat the question? I'm sorry, I got
Yeah.
lost.
Effectively, what you do with the risk adjustment approach is you ask the question, what would someone have paid for the territory or the access to the resources in the territory, excuse me, in 1850 at the time of treaty, correct?
I don't agree with that. The only distinction I would make is it's the value of the NCRs.
So thank you for that correction. So you would agree that it's a one-time purchase transaction model?
No, I think it's an upfront valuation, which is useful in valuing, in determining what contracts the Crown would be willing to enter into, whether those are upfront purchase contracts or some other kind of time purchase, if you like, contract.
And you say that at paragraph 66, in the middle of the page, paragraph 66, in short, the value the Crown placed on future risky NCRRs was the risk-adjusted present value as we have defined it here. In measuring what the Crown could offer under the augmentation promise of 1850 without incurring loss, the relevant value is the risk adjusted present value in 1850, not the unadjusted present value that may be calculated today with the benefit of hindsight. So you're looking at it from the perspective of someone making decisions in 1850. Would you agree with that?
Yes,
Would you agree with me that if the bargain in 1850 was not to transact a purchase of the NCRR value, but instead was to take a wait and see approach for the future, the risk adjustment approach does not make any sense?
no, I don't agree. The Crown still had to form, in my opinion, the Crown was attempting to form an expectation of what future NCRs would be with a view to determining how much should be offered in annuity payments.
Yeah, I apologize. I don't think I made my question clear. If the bargain, and I appreciate, you don't have to agree, let's use a hypothetical. The hypothetical is that there's a bargain between the Crown and the Anishinaabe that they will take a wait and see approach to what becomes of the revenues from the treaty territory. If that is the bargain that you are economically trying to model, you would not use a risk adjusted approach. You'd use a wait and see approach.
I don't agree. I would still compute this in the same way. Let us imagine hypothetically that augmentation, that the wait and see approach you've described means that as NCRs came in, all of them would be paid to the annuitants, to the Anishinaabe.
No, I'm not suggesting
That's
that.
not it?
No.
Okay, I'm sorry, I misunderstood you.
Yeah, no, I'm suggesting that let's suppose the bargain was we'll take a wait and see approach. And when $100 comes in, we will sit down and engage in a process to figure out how much share would go to the Anishinaabe and how much share would go to the Crown. Now, you wouldn't use a risk-adjusted approach to do that kind of modeling of an agreement, would you?
I would, yes, I would, because the Crown would be hypothetically thinking, we are about to sign a contract treaty that will give away the NCRs to a non-Crown party, the Anishinaabe. And they would wish to know the expected opportunity cost of giving away.
So who's giving away the NCRs?
The Crown. The Crown in your hypothetical, as I interpret it, they were going to sit down and once they know what NCRs are based on the wait and see approach, they would then determine the amount that would be given to the Anishinaabe treaty parties so that they would wish to know in advance, if they were to agree to do that, they would wish to know an estimate what that would cost them. That would require determining the opportunity cost there. That is the value of the funds that they were engaging to forego under that wait and see approach. Those would be risky funds that would be foregone, and therefore they would be valued using the risk adjusted present value approach. In addition, the wait and see approach would introduce new risks, which is, if I understand you correctly, they wouldn't even know quite what share they would be paying to the Anishinaabe. And those additional risks could also, if we had an estimate of what those shares might be and how risky they were, they could also be valued under our risk adjusted present value approach. We do not do that because that's not part of our model of how annuitization would have worked.
Yeah, I appreciate it's not part of your model, but the premise of your your answer presumed that the Crown starts off with beneficial ownership of the resources. Doesn't it? You just said that. Did you mean that?
I was trying to think through the wait and see approach and what it meant. And so conditional on my understanding of your wait and see approach, the Crown would be comparing two possible alternative treaties, one in which they had, quoting your term, just for clarity, I don't quite know what it means as an economist, beneficial ownership of the NCRs, and another one in which they engaged to give some share of them to the Anishinaabe under a wait and see approach. The difference between those two possibilities could be valued using the risk adjusted present value of the NCRs. And that's what I said.
Does your model depend on an assumption? And does it matter who owned in 1850 before the treaty? Does it matter who is beneficially entitled to the resource rents from the treaty territory?
I don't feel I have sufficient expertise to understand the term beneficial ownership as this court would understand it. But if I could put it into plain language that makes sense to an economist, the question is, what would they be prepared to pay without incurring loss? We interpret without incurring loss as being a reference to the NCRs. If they sign the treaty, they would have the NCRs. If they pay augmentation, they will give up some of those NCRs to the extent it's possible to do so without incurring a net loss. That is, without making payments to the Anishinaabe under the augmentation promise that would exceed the NCRs.
Yeah,
So
Maybe, I think Mr. Schachter might explain what he means by beneficial ownership. Because it's possible that in that last answer, you were not appreciating where he was coming from.
I'm going to try again and try and deal with what I mean by, let's start off by, in my hypothetical, and what I mean by beneficial ownership. By beneficial ownership, I mean the legal right to benefit from the resources. I'm going to confine it to that for now. So for example, let's suppose that a territory has only one asset in it, and it's a gold mine. And when I mean beneficial ownership, I mean the person who has beneficial ownership has the legal right to extract the wealth from the gold mine and doesn't have to share it with anybody. So that's what I mean by beneficial ownership. There's no treaty yet. And I'm just wondering whether your model depends on, or it matters who has the right to exploit and benefit from the natural resources before a treaty is made.
if I understand you correctly now, the term beneficial ownership refers to a right to collect the rents from, in your example, the gold mine,
Yes.
rather than the NCRs. The answer is no. Our approach has no implications for beneficial ownership in that sense. Our approach relates entirely to the NCRs accruing to the Crown, not the rents accruing to the owner of the mine.
Okay, so let's put ourselves back in the shoes of the Anishinaabe and the Crown in 1850. And again, I want you to treat this as a hypothetical because I appreciate your model assumes that there's going to be a valuation in 1850. And I understand your model, you've explained it to the court, but I want to deal with the hypothetical. The treaty parties sit down, and the first thing that they recognize and agree upon is that without a treaty, the beneficial ownership of the resources belongs to the Anishinaabe, not the Crown. The first assumption that I'll ask you to make. They then enter into an agreement that they will take a wait and see approach. And if and when, and again, let's just confine it to one gold mine in the territory. If and when that gold mine ever produces any income, they're going to share it in some fashion. Now, when that is the bargain, You don't need a wait and risk adjusted approach because the two parties can just wait until there is or is not income and share it at that point. Would you agree?
You're asking me to imagine a broader treaty-making process in which what was at issue was the economic rents to resources rather than the NCRs. And I'm willing to answer questions about that. I think I agree with the specific hypothetical you just asked me. In the interest of doing this right for the court, I want to remind you that Professor Bodway intends to testify regarding the differences between us and Professor Stiglitz. You, in this case, are probing, you're asking me about the economic rents approach in contrast to the NCR approach. I am prepared to answer those questions as a co-author of our reports. I do have opinions, but I want to remind you that Professor Bodway will talk about it. It may be in the court's interest that you wait and ask questions to him. But that being said, I believe the hypothetical you asked, my answer is yes.
You would agree with me?
I think so.
All right. Now, if we switch it from rents to NCRRs, would you still agree with me?
That, oh, nice. Allow me to think for 1 minute. Any arrangement that the Crown enters into which commits it to sharing NCRs involves alienating those NCRs from the Crown, committing to do so. And that will have a cost for the Crown relative to an alternative in which, as is normal, all of the NCRs accrue to the Crown. In the absence of a revenue sharing arrangement, NCRs accrue to the Crown. Therefore, any such arrangement involves a cost. The cost is that NCRs that would otherwise be collected will not be collected. Those NCRs have an expected value in the future, and it can be valued using the risk-adjusted present value approach. So I don't agree with you.
Why would you have to risk adjust anything in, let's follow the hypothetical. There's a wait and see approach agreement entered into, and lo and behold, in rather than use made up numbers, let's just use the numbers from the treaty. Let's go to your table C2, which is found at tab 11 of the compendium of volume 1. And to page 33. And look, here's my hypothetical. The parties into the Anishinaabe and the Crown enter into a wait and see approach because no one knows if there's ever going to be any revenues to share. They make an agreement that they'll wait to see what happens in 1951 to see if there's revenues to share. They wait in 1951 and they look and see that there's $1,216 to share. Now, in order to share that $1,216, they don't need a risk adjustment approach to share that, do they? We're in 1851.
I disagree. The Crown should think about the risk-adjusted present value of that future amount in deciding whether to engage in any commitment to not collect NCRs on its own behalf.
No, but they've already, you're missing the point. They've already entered into an agreement in 1850 that they're going to wait. The premise of my question is that they've entered into an agreement to wait and see.
That wasn't the hypothetical that I understood you to be asking me about. I thought the hypothetical was, if the Crown is considering entering into a wait and see approach, what valuation principles should they use?
No,
Now you've changed it so that they've already entered into that.
yes.
But then I don't think there's any need to do valuation of the promise. The commitment's already been made. The valuation of it would be irrelevant at that point. The Crown had made that commitment.
Thank you.
When you say valuation of a promise, you're talking about the risk adjustment.
The promise I'm talking about is the augmentation
No,
promise or the
the
augment.
valuation of a promise, that phrase, you say there is no need to do valuation of a promise.
Yes,
Is that the risk adjustment?
the risk adjustment is our approach to valuing the promise. Yes,
I was just trying to.
yes,
Yes.
no, you're absolutely right.
Yes,
Thank
we've
you.
squared that circle. Thank you. Would you agree with me that there was a shared understanding in 1850 among the treaty parties that the Crown would share the wealth from the treaty territory on an if and when basis?
Yes, in the sense that I believe the augmentation promise is a promise to increase annuities that is contingent on the NCRs the Crown would subsequently connect. That's a wait and see basis.
So I just want to make sure we're talking about the same wait and see basis. And so perhaps we can go to the compendium at exhibit V.1. And we're going to look at the trial decision, paragraph 466. I believe, I hope it's in here.
Could you give me the tab number?
Yeah, hold on. Tab 2, I'm on the wrong tab. Yes, okay. Page 10 of the compendium, tab 2. And I just want to make sure that we're both on the same page when we're talking about the if and when sharing model. So the trial judge said at wrote at paragraph 466, a plan to share the wealth on an if and when basis through an augmentation clause was always central to the understanding, the aspiration, and the intent of both the Anishinaabe and the Crown. And do you agree that sorry, I shouldn't say that. Let me back up. You see that that's what the judge said.
Yes,
And did you factor that into your opinion?
yes,
And if there's an if and when approach, and isn't that the approach to looking to see what happened in 1851? And you wouldn't need a risk adjustment approach in 1851, would you? If there's a wait and see or an if and when approach.
I don't agree. And I don't think that if and when approach means a joint venture or a fixed sharing rule. I think it means that payments under the augmentation clause are contingent on the values of NCRs realized in the future.
Perhaps for a moment, we can go to the compendium and see what Vidal and Anderson had to say. And you'll find a copy of their report that is at trial exhibit 1-6395. And at page 5 of 16, at page 68 of tab 24 of the compendium, about the third paragraph up from the bottom. It will not be easy to ascertain the actual value of the vast but sterile territory on account of it being so little known. But while making terms in accordance with present information of its resources, provision might be made, if necessary, for an increase of payment upon the further discovery and development of any new source of wealth. So, would you agree with me that that's consistent with a wait and see approach?
Yes,
At paragraph 71 of your, I guess it's the present value report, we'll take a look at it. You opined that the evidence from the Vidal Anderson report suggests that the Anishinaabe were uncertain about the revenue potential of the territories. And that statement or that proposition you refer, is that the proposition to be found by reference to paragraph, sorry, your footnote 34? You reference a couple paragraphs of the judgment.
I think that may be the reasons for judgment.
Yes, I don't want to take issue with that assertion because I do believe there was uncertainty and I don't think that's
Oh.
disputed.
Okay,
It's the next one. And they sought to avoid risk, preferring a fixed perpetual annuity payment rather than a share of NCRRs. And you've got a footnote there, 35. And you refer in support of that proposition to a number of paragraphs of the of judgments. And is your opinion, how much does it depend on this proposition that the Anishinaabe preferred a fixed perpetual annuity payment rather than a share of NCRRs? Is that important to your opinion?
it's certainly part of our opinion, and it's consistent with our economic model that almost all humans prefer a safe outcome to a risky outcome. Yes, I would say it is important.
And would you agree with me that if the Anishinaabe did not prefer a fixed perpetual annuity payment, but instead wanted a share of NCRRs and a perpetual annuity payment, would your opinion be different?
No, I don't think it would. Because that would suggest that they still place a value on a fixed annuity, perpetual annuity payment. All of us humans would like more most humans seek to increase their incomes, and they would therefore wish to increase their income in every form, whether it was a certain amount like a perpetual annuity payment or a risky amount like a share of NCRs. So I don't think that's inconsistent with what we're saying here. And I will stop there. Thank you.
Can I just ask a question?
Yeah.
You're saying in any bargaining situation, I'm not sure if you said a rational human or every human, almost every human would choose a fixed sum rather than an unknown.
If I said that, I should just add one qualification,
I may be wrong, so go ahead.
that that almost everyone would prefer a fixed sum to a risky sum that has the
Risky.
same average or expected value.
Okay.
If the risky alternative has a higher expected value, then if it's sufficiently higher, many people would say, I'll take the risky one instead. They would be willing to bear that risk in order to get those higher returns. It's the trade-off between those two things that we're trying to express through our risk-adjusted idea.
Where I'm having trouble accepting this, almost everyone would, is I'm thinking about labor negotiations. So from a Sudbury perspective, So in labor negotiations, it's not unheard of for there to be bargained a fixed hourly rate increase
Yep.
and a nickel bonus. The bonus had to do, I think it was quite complicated figuring it out. I don't know what it was, but it was unknown. And I presume that in a bargaining situation where one can't always get their first choice, which might be known and fixed rate, for instance, of increase, they might bargain for something else. So isn't that the nature of bargaining?
Yes, I think so. I think what Your Honor describes is very close to the standard economic model of an efficient bargain. And I can explain in maybe 2 more sentences. We think everyone, when they go to the bargaining table, they're trying to get the most they can for themselves. And the most they can could come in different kinds of payments. And they, all else equal, they just want more of all flows of positive possible payments. The bargaining process is in part about determining, well, which one do you want the most? What's most important to you? Do you want this safe payment of a fixed wage rate, or are you willing to gamble on a nickel bonus, for example? And the 2 parties to that would engage in negotiation to determine what was the efficient mix of those 2 things to be agreed on. And so I can talk more about the reasons why some sharing of risk of that kind could be part of the efficient bargain in general. In this case, we think the efficient bargain was for the Crown to take all of the risk, or almost all of the risk, and for the Anishinaabe treaty parties to get a much safer return. Our augmentation model doesn't deliver a fixed annuity for all years in the future, as Your Honor knows, but it's pretty safe.
Right. I'm not talking about what the bargain was, just what I thought you said was pretty much everyone would seek to achieve something certain. So I have what you say. Thank you.
Professor Smart, I want to focus at paragraph 71 of your report on your assertion that either the trial court or the Court of Appeal came to the conclusion that the Anishinaabe preferred a fixed perpetual annuity payment rather than a share of NCRRs. Now, let's take a look at what you cite. You cite the Ontario Court of Appeal at paragraph 53, when we have paragraph 53 at tab 3, says the next day, Chief Podeshat, I'm looking at page 12 of the compendium, tab 3. The next day, Chief Podeshat told Robinson that the superior delegation was prepared to sign a treaty. Chief Shingwekons of the Huron delegation, on the other hand, was not. Chief Shingwekons made a counter proposal for an annuity of $10 per head. Robinson rejected this proposal, telling Chief Shingwekons that a majority of the chiefs were in favor of the terms and that he was going to write up the treaties on the basis approved by the superior delegation. And is it your understanding that this reference to $10 per head is to $10 fixed perpetual annuity?
In respect to the specific proposal Her Honor is talking about in that sentence, yes, I do believe $10 per head is a fixed perpetual annuity.
So you thought they were asked that Chief Shingwekons was asking for a fixed perpetual annuity?
I think there's some dispute of whether he was asking for that. There's some question whether he was also asking for something else, which, as I said, everybody in a bargain has a right to ask for.
Well, but it's not an issue that's left unresolved, because you do appreciate that the trial judge and the Court of Appeal made a ruling that Shingwekons was not foregoing asking for a share of revenues or a share of the wealth, and that the $10 ask could have been a starting salary that they were going to receive, not a fixed perpetual annuity. Do you know that?
I am aware of those discussions, and I'm not 100% aware of precisely where the court landed on it. But it would not, these issues would not cause me to change my opinion that the Anishinaabe treaty parties preferred a fixed perpetual annuity.
Perhaps this would be a good time
Thank you.
to
Just,
break for the day.
thank you. I'll just catch up. Okay, we'll break for the day then. It's 4:40. Just before we break, Mr. Schachter, can you let me know? And then then Group of Seven and Ontario, how you think tomorrow looks?
I'm looking that I maybe have 2.5 hours to go.
Okay.
I'm guesstimating.
Thank you.
I've been able to cut down a little bit on my anticipated cross, but I would still estimate somewhere in the range of 2 hours to half a day at most.
And Ontario?
I think currently as we stand, possibly 15, 20 minutes.
Canada, are you in? Thank you. Okay, so it looks like we have a full day tomorrow.
Unless the court wants to start early, I leave that option open to anyone. I know some people want to head to
Catch planes?
Toronto. Well, I don't know that there's planes to catch, but they
Oh.
might be driving.
They want to go fast or. I'm open. If anyone is proposing a different start time, I'm quite open to it.
Well, if there might be a better chance of actually completing tomorrow, if we started at 9:30, but I don't know how the witness feels about that, starting early, or anyone else in the court, but I would make myself available if it makes a difference to not having to hold the witness over till Monday.
No objection, Your Honor.
To 9:30?
I mean, that's the wrong word, I know. I don't mind.
I can't make any guarantees, but I will try.
All right, let's start at 9:30. See if we can do it. Thank you.